Welcome back for the second part of the International Space Law lecture. This is going to dive a bit more deeply into the actual international space law specifically. And so we're going to address the second and third lesson objectives here in this portion of the lecture. So identifying challenges for current and future military space operations regarding existing laws and the establishment of norms, and relating existing legal considerations to military space operations, including US and international laws, agreements, and norms. So in this PowerPoint, we're going to go through some early history of international space law, talk about the differences between air law and space law, the issue of demarcation between air and space. We're going to focus most of the time in this discussion on the key principles of the Outer Space Treaty, and we're going to talk a little bit about the subsequent UN COPUOS treaties. I'll mention the Limited Test Ban Treaty, which I also mentioned in the first presentation, and just highlight ITU and frequency management as another important consideration for international space law. So I'm sure you recognize the first man-made object in space, which is Sputnik, that was launched by the USSR in 1957. That was the first time we had to consider what space law might be as distinct from air law, or as distinct from any other form of international law. So you see here the newspaper headline when Sputnik was launched, that it tracked in 4 crossings over the United States. Well, why is that legally significant? It's legally significant because in international air law, states have sovereignty over their airspace. So here I've put the language of Article 1 of the Chicago Convention on International Civil Aviation. This is from 1944-1945. It has 193 contracting states, so it's universally adopted internationally. But this is a codification of an existing rule of customary international law that predates World War II, that states have that complete and exclusive sovereignty over their airspace, to control their airspace, to determine who is allowed to use it and how they're allowed to use it. By contrast, here's Article 2 of the Outer Space Treaty, which came into force in 1967 and now has 110 ratifications, including all of what we think of as the spacefaring states, especially the major spacefaring states. And Article 2 tells us that outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty by means of use or occupation or by any other means. So in the air, states have complete sovereignty, jurisdiction, control. In space, states do not have any sovereignty over that area, whether we're talking about the surface of a celestial body or whether we're talking about a particular orbital slot or orbital path. States don't own those. They don't have specific rights to them as you would have over a territory. So there's no territory. If you remember back to that first presentation, territorial jurisdiction is the strongest form of jurisdiction. It is not a form of jurisdiction that exists in outer space. Instead, you have quasi-territorial jurisdiction over a state's space objects, and you have personal jurisdiction over a state's individuals that go into outer space, but you do not have that territorial jurisdiction in outer space. So that's kind of an interesting question, an interesting problem, right? You have 2 different legal regimes that are actually opposite from each other in terms of the rights that states are granted to manage those spaces. And they're presumably right up against each other, right? You cross out of airspace and you cross into outer space. So where does airspace end and outer space begin? Or put another way, what's the boundary of a state's sovereignty? And the legal answer is, we don't know. You can make a number of different scientific or technical assertions as to where airspace ends and outer space begins. But we don't have a legal boundary. There is not a legal boundary that exists. So we talk about 2 different approaches to how one might develop a legal boundary between airspace and outer space. So one group of approaches is called spatialist. And what that means is that you would use a specific boundary based on a specific principle to determine where airspace ends and where outer space begins. So the most common one is the von Karman line. That's 100 kilometers. That one you see referenced, and there are a couple of states that actually have codified in their domestic law that from a domestic perspective, that is the boundary between air and space. But internationally speaking, there is no codified boundary. The functionalist approach would say, well, we tell the difference between air and space based on the purpose of the activity. Is it an aviation activity or is it a space activity? Well, for a lot of activities, it's pretty straightforward. You're putting the space shuttle up when we had a space shuttle to go to the International Space Station, or now we're putting up SpaceX Dragon to go to the space station. Okay, that's pretty clearly a space activity. You're going to an orbital station, whether it's with people or without people, right? Cargo or crew, space activity. But if you're using a vehicle that can undertake activities that might be considered air or space activities, depending on what they're doing, that becomes more complicated. You wind up having a vehicle that sometimes is a space vehicle and sometimes is an aircraft. Take, for example, Virgin Galactic's Spaceship Two. So right now, Spaceship Two has been used primarily just to go up and back from the same spaceport. And so from that perspective, if there are people on board, they might be engaged in what we're going to call space tourism, right? As Virgin Galactic's bringing them to space. You might have people who are doing microgravity research, or you might have experiments that are not being operated by humans being conducted on those flights, so that when the Spaceship Two vehicle is at the height of its flight, you are conducting those microgravity experiments. That looks like a space activity. Both of those things I mentioned look like space activities. But if you start using that same vehicle for point-to-point transportation to get from New York to Tokyo in 2 or 3 hours instead of the 15 hours that it would normally take, at that point, even though you might be crossing the threshold from a spatialist perspective above the von Karman line, the activity looks more like an aviation activity. The purpose is to transport people from one place on Earth to a different place on Earth. And so that could become very complicated very quickly in terms of, okay, how do we determine which activity this really is? Up until this point, the majority of activities have been pretty clearly either air or space activities, but that could change as we start to have more vehicles that are operating in this gray area, like Virgin Galactic Spaceship Two, and like also, for example, high altitude ballooning activities, which typically, as you see on the slide, do not go above 50 kilometers or are limited to 50 kilometers by the physics. However, you have a number of companies, and I've seen examples both in the US and Europe, that are proposing activities that they're marketing as space tourism. That you would put people in a capsule attached to a high altitude balloon, and it would go up to such an altitude that you could see the curvature of the Earth and feel like you're in space. And if you're wondering if it really looks like space at that point, there's a video from Felix Baumgartner and Red Bull from a number of years ago at this point that shows Felix Baumgartner jumping from a high altitude balloon, and you see the curvature of the Earth. It looks like space. And that balloon doesn't go quite as high, certainly not quite as high as some of the balloons that have been proposed by, for example, Worldview Enterprises in the US or Bloon in Spain. So interesting questions to consider as we continue to develop human activities and uncrewed activities in space as well. Okay, so the international forum where the Outer Space Treaty and its progeny have been negotiated is the Committee on the Peaceful Uses of Outer Space, which is also known as COPUOS. It is a UN committee, United Nations committee, and you can see there the list of how the membership has grown. So when it was first formed in 1958, there were 18 members of UN COPUOS. By 2020, 95 members. Quite a substantial amount of growth that you see taking place. A big jump in particular between 1980 and beyond there, although there's pretty good progressive growth of the committee moving throughout the decades of its operation. There are two co-equal subcommittees for UN COPUOS, the Legal Subcommittee and the Scientific and Technical Subcommittee. Typically the way the schedule works, STSC meets in February every year, Legal Subcommittee meets in April every year, and then the plenary, UN COPUOS, meets in June every year. That all happens in Vienna. and is supported by the Secretariat, which is the UN Office of Outer Space Affairs, UNOOSA. And UNOOSA has some very valuable information on their website, so I highly recommend using that as a resource. They have not only the documents providing all of the treaties, all of the resolutions, the status of the treaties that show you specifically which countries are party to which treaties. They have a database of domestic space law. They have the UN Registry of Space Objects. They have the Travaux Préparatoires that I mentioned, that negotiating history for the UN space treaties, all linked from their website. So if you're looking for those resources, that's a great place to go. I think that it's important to point out here that you can see the importance of space law when you consider that the Scientific and Technical Subcommittee is co-equal to the Legal Subcommittee. So of course we need the scientists and engineers to get us into space and operating in space, but we also need a legal regime that's going to support continued development of human activity in space. Whether there are humans in space or not, they're still human activities if they're generated by humans on Earth, without creating an international incident, without creating international conflict, without producing insecurity in the world. And so that legal piece is incredibly important. One more thing I'm going to point out before I dive into the treaty language here, and I know there's a lot of text on the slides. It's the same text with the exception of my emphasis that's been added through bold or underline or italics. It is the same language from the treaty. So you can always pull up the treaty document too. I just want to have it right there in front of you while I'm talking to you about it. But the one other point that I want to make is that we have not had a new binding treaty emerge from UN COPUOS since the Moon Agreement in the early 80s. So my point being, there are a couple of reasons you might consider for this fact. One, UN COPUOS operates by consensus, which means that if one state votes no or objects, then the document will not be accepted. So when you operate by consensus, getting consensus from 18 countries or even 37 countries is a whole lot easier than getting consensus from 95 countries to agree for new treaty language. The second point is that in the international community, there has been much less political will for binding international agreements. There's been a shift in favor of soft law non-binding agreements to be used at the international level. And so we've seen UN COPUOS move that way as well. So there have been a number of UN resolutions, non-binding, that have come out of COPUOS following the Moon Agreement, but no more binding treaties. One of the interesting points about how soft law can be used is that if states' behavior does not comply with a soft law instrument, then none of the states who help negotiate it are bound by its provisions. So if one state's a bad actor and other states therefore say, well, I'm not giving up my rights to do certain things if other states aren't going to comply, great. There's no binding law to violate. However, if states do act in conformity and consistently under that consistent state practice prong, then you can see the development of customary international law that will bind states, and or you can use those UN resolutions as subsequent agreements or the practice as subsequent practice in support of an interpretation of, for example, the Outer Space Treaty. So it gives flexibility that there's not a binding document that you would have to withdraw from if you see other states not behaving in conformity. You would simply ignore it because it's not binding, and if other states aren't conforming with it, there's no way for it to possibly become binding international law. Okay, Article 1 of the Outer Space Treaty sets out our fundamental principle, that outer space is going to be free for exploration and use by all states, right? Exploration and use, that's underlying. Every state gets to do that. Now, I want to point out a piece of language in the first paragraph, which is province of all mankind, because you'll hear discussion about common heritage of all mankind. That's the language that's used in the Moon Agreement. It is not used anywhere in the Outer Space Treaty. The common heritage of mankind implies some potential further restrictions that are beyond the scope of this point of this presentation, but the province of all mankind does not have a specific meaning, specific legal meaning attached to it. And in fact, if you look at that language, the thing that is the province of all mankind is not even outer space itself is the province of all mankind, but rather the exploration and use of outer space shall be the province of all mankind, right? The activities are the province of all mankind, not that the domain itself is the province of all mankind. Just an interesting interpretive point when folks are arguing about, well, what does that mean? Is outer space a global commons? Is it the common heritage of mankind? How do we have to treat outer space? That province of mankind language ties back into the activities. There's a lot of emphasis throughout the Outer Space Treaty on freedom of scientific investigation in particular, and the encouragement of international cooperation. So no requirement for international cooperation, but consistent encouragement that it should take place. Okay, I'm skipping Article 2 here because you already saw Article 2 at the beginning when we were talking about delimitation between air and space. But if you recall, Article 2 is the non-appropriation principle. You don't have sovereignty in outer space, no territory in outer space. Article 3 is where we tie in international space law to the rest of international law. So activities in space are carried out in accordance with international law. UN Charter is specifically mentioned here, but this is true of international law in general. So LOAC, for another example that we referred to in the first presentation. The Outer Space Treaty and space law are lex specialis, as in specialized law dealing with outer space. So if there's a specialized rule for outer space that's different than other international law, then that's going to be the rule that controls. But where there is no specific space law, then you will apply general international law. Article 4 is particularly of interest to this audience. So Article 4 is the peaceful purposes article. This is where you find limitations specifically on military activities. And this is one that is very, very often misrepresented in discussions of the Outer Space Treaty. And that has become less true in the last few years, but there was historically a bit of an overextension of some of the language here in Article 4 in places where it doesn't apply. So let me explain that. The first paragraph applies to all of outer space. It applies to orbital space, what I call the void of outer space, right? Orbital space, deep space, everything in between, including celestial bodies. And that first paragraph says that states parties are not going to place in orbit around Earth objects carrying nuclear weapons. It doesn't say nuclear devices, it says nuclear weapons, or any other kinds of weapons of mass destruction, WMDs. In a terrestrial context, we tend to think of weapons of mass destruction as nuclear, chemical, and biological. And those would still apply in outer space. There are arguments to be made that there might be types of weapons that would be considered weapons of mass destruction if employed in a space context that might not be mass destruction if employed in a different context. And that's an open question. But for example, a tungsten rod the size of a vehicle, a car or a van, dropped from orbit could cause really significant destruction, just one object on the surface of the Earth if it hit in a major population center. And so some folks will argue that that could qualify as a weapon of mass destruction if placed for that specific purpose and engineered to be used in that manner. Open question. And those types of weapons can't be installed on celestial bodies or otherwise stationed in space. So no Earth orbit, no stationing, so no putting them in orbit around another celestial body either, and no installation on celestial bodies. But if you sent it just on a deep space trajectory, if you wanted to send a nuclear weapon on a deep space trajectory, there's not an express prohibition on that in Article 4. That's it. There's no limit on conventional weapons in space from a legal perspective. Now, there might be policy limitations or political limitations, but it's not a legal limitation on weapons in orbit or in the void of outer space. Now, when we're talking about celestial bodies specifically, other than Earth, that's a different story. Celestial bodies have to be used exclusively for peaceful purposes. That's where this exclusively peaceful purposes language comes in. It's not for all of outer space. although you will hear some folks argue that space is to be used for exclusively peaceful purposes, it's really, legally speaking, celestial bodies to be used for exclusively peaceful purposes. There are some specific limitations articulated, and there are some specific allowances articulated here, and those align very closely to what you will see in the Antarctic Treaty as well. And as you know, military resources, personnel, and equipment are used significantly in Antarctica to provide supply and transportation in that inhospitable environment. And so the expectation is, while the activities themselves may be different, those peaceful activities would still be carried on by military personnel and using military equipment on celestial bodies as well. As I said, it might look a little different than it looks in Antarctica, but peaceful activities by military personnel and military equipment are fine. Any activity for peaceful purposes. Okay, Article 5 requires the safe and prompt return of astronauts who may find themselves returning to Earth somewhere other than their home state. And states are required to render all possible assistance to the astronauts of other state parties in carrying on their space activities. That's paragraph 1. And then paragraph 2, states parties shall immediately inform other states parties of any phenomena they discover in space that could constitute a danger to the life or health of astronauts. So really you see here in Article 5, this preservation of the special status of astronauts. You see them referred to as envoys of mankind. And I tag Return and Rescue Agreement at the bottom there because we'll talk about that on a subsequent slide. Article 6, I've put a whole bunch of little stars here because this is an incredibly important article of the Outer Space Treaty because it differentiates international space law from the rest of international law in a very significant way. So under general international law, not space law, for an action to be considered an action of the state, it would have to be carried on by either an organ of the state or an agent of the state specifically being employed to carry out that activity on behalf of the state, for the state as if it was part of the state. Right? There has to be a principal-agent relationship under general international law for the activity of a private company or a private individual to be considered a state activity. So under general international law, something that a private company does that's wrongful, as long as they're not under a specific contract by the government, is not going to be imputed to the state. They're not going to be considered to be responsible for that behavior. However, in international space law, the activities of private entities, non-governmental entities, are imputed to the state. The state is directly responsible for the activities that its nationals carry on in space, whether they're doing it on behalf of the state or not. This was a compromise that was reached between the United States and the USSR at the height of the Cold War. The USSR didn't want to allow any private activities in space at all. Not surprising, given the nature of their form of government. The United States wanted to allow private activities. It was already apparent that there was going to be significant potential economic benefit that could be gained from space. Even at that time, looking at telecommunications and remote sensing opportunities, but commercially, particularly telecommunications, broadcasting. And so the United States wanted to have those private activities. And the compromise was, okay, states can have private activities, but they have to be treated as if they're the actions of the state, even if it's not a specific principal-agent relationship. And so, in order to facilitate that arrangement, states have to provide authorization and continuing supervision of their space activities. Authorization is typically in the form of a license or a permit, for example, that would be granted. So in the US, we use the FAA Office of Commercial Space Transportation for licensing or permitting of launch and re-entry activities, as an example. Article 7 talks about liability. So Article 6 is responsibility of states to authorize and provide continuing supervision for their space activities. Article 7 is liability for damage caused by space activities. And this principle is elaborated in the Liability Convention, and we have a slide on that later. But states are liable at the international level for damage that is caused by their nationals in space, even if they're not specifically acting on behalf of the state. So it's in a state's best interest to provide good oversight of their space activities, because if they don't, they're potentially on the hook to pay out for those space activities. And this is also where insurance requirements typically come in. Most spacefaring states require that their private entities have insurance to engage in space activities. So if damage is caused, even though the state will have to initially pay it out, there is an opportunity for them to get that money back based on the company's insurance policy. Okay, Article 8 tells us that a state on whose registry an object is launched into space will retain jurisdiction and control of that object. So the state that registers retains jurisdiction and control. This is the only mention of registering in the Outer Space Treaty. We subsequently get the Registration Convention that helps to explain what registration looks like and what registration is. But from this language, we get that a state has to have a registry, and when they register the object on that registry, they're the state that retains jurisdiction and control over that object. So if you think about that quasi-territorial jurisdiction that we talked about in the first presentation over aircraft, over vessels on the high seas, and over space objects, this is how you attach that jurisdiction to space objects. Ownership of objects is not dependent on where it's found. So if you have an object that's found in space, you have an object that comes back and lands in the territory of another state, it still belongs to the state of registry. And if objects are found beyond the limits of the state, they can be returned to the state party that registered them upon request. And there's more elaboration of that in the Return and Rescue Agreement as well. Article 9, there's a lot there. It's a lot of text. I don't expect you to read it all right now. There's essentially 3 different key provisions built into Article 9 here. The first and most significant is due regard, that states have to act with due regard for the corresponding interests of all other states. I call this expectation of acting with due regard the prime directive of international space law. That's because I am very admittedly a science fiction and a Star Trek nerd. For those of you who are Star Trek fans, you know that the prime directive is the non-interference directive. In Star Trek, it's non-interference with primitive civilizations, but here it's non-interference is in due regard for other states' space activities. Another prong, which is the third prong in terms of the listing of the text, is that states are obligated to engage in consultations if they believe that their activity could cause potentially harmful interference with another state. And so there's not a blanket prohibition on causing that harmful interference, but there's a requirement to try to resolve it through consultations if a state knows they're going to potentially harmfully interfere. And if a different state sees a possibility that the first state's space activity will interfere with them, even if the first state doesn't necessarily realize that, then that state who sees the potential for being interfered with can request consultations from the state they think is going to interfere with them. So that's 1 and 3, prongs 1 and 3. And if you look at that bold text, that's what I'm talking about here. The bit of bold text in the middle is its own provision here in Article 9, which is the avoidance of harmful contamination and adverse changes to the environment of Earth. So avoid harmful contamination of other celestial bodies. That's what we call forward contamination. And then avoid adverse changes to the environment of the Earth resulting from the introduction of extraterrestrial matter. That's what we call back contamination. Avoid forward contamination and avoid back contamination. And there's some guidance that we might be able to use to help us interpret this provision. So there's the COSPAR Planetary Protection Policy, which is not binding law, but gives some guidelines for how we can avoid both forward contamination and back contamination. And that document has been widely adhered to by space agencies undertaking activities that are going to other celestial bodies in the solar system. Before we move on to the final provisions of the Outer Space Treaty, I also just want to mention about due regard that this principle of due regard in Article 9 is a hook by which you can bring in lots of other norms of behavior, lots of other agreements as to standards of behavior, rules of the road in outer space, Because states are intended to act with due regard for the corresponding interests of other states in space, you need to have some underlying rules of, okay, well, what does due regard look like? What does it look like to act with due regard for other states? Well, if we have some agreements, for example, like the IADC debris mitigation guidelines that tell us how we act with due regard specifically with regard to debris mitigation, then we can use those rules if we get consistent state practice, and we can show that states believe that they're bound to continue to engage in that consistent state practice in accordance with those rules, either as a customary international law rule on its own, or as a means of interpretation using the IADC debris mitigation guidelines to help us interpret Article 9 here, or by using the subsequent practice under Article 9 of the Outer Space Treaty in accordance with the IADC debris mitigation guidelines to demonstrate that interpretation of the Outer Space Treaty. So you can use state practice to help with treaty interpretation when you're talking about treaties or conventions, sources under Article 38(1)A of the ICJ statute. You can use state practice as one of two prongs, along with evidence that a state believes they're bound, in order to find a rule of customary international law under 38(1)B of the ICJ statute. Okay, final provisions of the Outer Space Treaty. So Article 10 deals with observations of launches from other states, representatives observing launches. Non-controversial, happens all the time. You'll see lots of international folks invited to and watching launches at, for example, Kennedy Space Center. Article 11 is a provision that we need to inform the Secretary General of the United Nations, as well as the public and international scientific community, of nature, conduct, locations, and results of space activities. But that's limited by that feasible and practicable language. So if it's not feasible or it's not practicable to share that information, then there's not a requirement to share it. So it's a very soft provision. It doesn't have a lot of teeth, and therefore we're not going to be required to share anything that could potentially cause national security concerns because it's not practicable to share that information. Article 12 establishes a regime for visits or inspections of other states' installations and celestial bodies. And I find this provision really interesting from a couple of perspectives. One, in 1967, we anticipated that very soon we would have not one, but multiple states with installations on celestial bodies. Well, it's 2021 and we don't even have one state with an installation on celestial bodies, never mind two, in order to have reciprocal visits or inspections. The other way in which this is interesting is that it means that there can't be a parallel customary international law rule regarding these visits or inspections because there has been no state practice to indicate how these visits or inspections could be used or how they could be carried out. So you'll hear lots of arguments that the Outer Space Treaty or several provisions of it have crystallized into customary international law. Crystallized is that term of art that we use when something forms into customary international law. And I would argue, and the majority of scholars would argue, that the fundamental principles of the Outer Space Treaty have crystallized into customary international law: freedom of access and use, non-appropriation, in particular, as well as state responsibility and liability. Those provisions have also developed in parallel not only with the Outer Space Treaty, but also under a prior UN resolution that articulated the same principles that were later included in the Outer Space Treaty. So I would agree that those principles have crystallized into customary international law. But I think it's impossible to argue that the entirety of the Outer Space Treaty has crystallized into customary international law because, for example, in Article 12, there's no state practice that would support whether that's a customary rule or not. And so you can't have a customary rule in alignment with Article 12. Article 13 talks about applicability to international organizations. Think, for example, of the European Space Agency that has a number of states engaged in space activities jointly. And then there are some administrative provisions that deal with the ratification, ratifying the treaty, withdrawing from the treaty, amending the treaty, and which languages are the authentic languages. And as I mentioned, it's all 6 of the UN languages that the Outer Space Treaty is authentic in. Okay, to go quickly through the other agreements here in the next few minutes that followed the Outer Space Treaty coming out of UN COPUOS. As I mentioned, Return and Rescue Agreement, 1968. So it deals both with the rescue of astronauts and the return of astronauts, as well as the return of space objects that might come back not to the territory of the state itself. It doesn't use the term astronauts in the articles of the treaty itself. It uses the term personnel of a space object. So you get this question as to whether there's a difference in obligation between an obligation to rescue an astronaut in the Outer Space Treaty versus an obligation to rescue personnel of a space object in the Return and Rescue Agreement, and how that may or may not apply to space tourists. There's a lot of information sharing that's required under the Return and Rescue Agreement, especially when you're talking about situations of emergency or distress in space. There's a provision for providing all necessary assistance to personnel and provisions for cooperation with a launching state in the case that there is some sort of emergency or distress. That safe and prompt return is carried through from the Outer Space Treaty. In terms of objects, states have to take steps as practicable to recover space objects if the launching state requests that. So if the object lands on the territory of another state and the launching state requests it back, then the state has to make reasonable efforts to try to recover that from their territory. In that case of an object, not people, but just an object, the launching state will have to reimburse the state that finds the object for its return. There's no mention of payment with regard to astronauts or personnel of a spacecraft because the principles, the sentiments of humanity control. So there's not an expectation that payment is going to be made in order to rescue human life. There are also steps to deal with hazardous or deleterious materials that might come back to Earth that are built into the Return and Rescue Agreement. This one's got 98 ratifications. 1968 is the year, 98 ratifications. Liability Convention 1972 creates two separate regimes for liability. One for damage that's caused by a space object that plummets back to Earth and causes damage either to an aircraft in flight or on the surface of the Earth, whether that's land or sea. And in that case, damage to an aircraft or the surface of the Earth, it's absolute liability. All you have to prove is that damage was caused and that damage was caused by a space object that belonged to a particular launching state or set of launching states. And if so, that launching state or launching states will be required to pay the victim state. If there is space object on space object damage in space, that's a different regime. You have to be able to prove fault, that something was done improperly in order to claim damages for damage caused from one space object to another. So a wrongful act in international law is one way to prove fault. A violation of standards of behavior might be another way that you could prove fault in order to recover for damage caused by a space object in space. There's joint and several liability, which means that if you have multiple launching states, the victim state can recover from either one. They can recover the full amount from either one. Victim-oriented treaty, right, protecting the victim. And then the states have to work out between themselves if one is going to reimburse the other. It's apportionment, right? And you can have separate proceedings to determine that, to apportion that fault, to apportion that payment between those states. But the payment to the victim can be expected from either of the launching states if there are more than one. Liability Convention doesn't apply to nationals of the same state. So if a SpaceX object falls back to Earth and damages the United States, people, property in the United States, then that's under domestic US law. That has nothing to do with the Liability Convention. Compensation is determined by international law and principles of justice and equity under the Liability Convention. And there is a set of procedures to establish a claims commission if that's necessary that looks a lot like an arbitral tribunal would look in international law to determine the outcome of a liability claim. You don't have to use a claims commission. You can resolve a liability claim through diplomatic channels, state to state. You could resolve it through an arbitration or mediation. You could resolve it through a claims commission that would be established in accordance with the Liability Convention. It also has 98 ratifications. The Registration Convention, 1975, requires registration when a space object is launched into Earth orbit or beyond. So a vehicle that's suborbital or non-orbital, like the Virgin Galactic Spaceship Two that we talked about, is not required to be registered. That being said, there's no specific prohibition on registering them, but there's no requirement. Registration is made both on a national registry and the UN registry, but that jurisdiction and control from Article 8 of the OST ties based on the national registry. It has to be a launching state under the Registration Convention that registers that space object. So a launching state is defined in the Liability Convention and in the Registration Convention. And it's designed, it's drafted to include a state that launches, a state that procures the launch, a state from whose territory or facility a space object is launched. So it has to be one of those states that's the registering state. In some cases, there's only one launching state, right? If it's a SpaceX object launched from Florida, U.S. territory, it's a U.S. facility, and U.S. procures the launch. It's SpaceX that's launching their own satellites into orbit, maybe the Starlink satellites, then there's only one launching state, it's the United States. However, if another country's entity procured that launch to put their own payloads into space, then you would have the United States and also another country who are both launching states, and either one could register. If you consider Baikonur Cosmodrome, it's on Kazakh territory. It's leased by the Russian Federation, so it's a Russian Federation facility. So you can potentially wind up with a number of launching states for any launch out of Baikonur, because there's Kazakhstan, the Russian Federation, and then any procuring state as well. You have to include information about orbital parameters, the launching state's designator and function of the satellite, and states with tracking and monitoring facilities shall respond as feasible under equitable and reasonable conditions to help identify an object when damage is caused. So you can require some sort of payment or reimbursement for use of tracking facilities and tracking information in order to help a victim state determine who caused them damage. Registration Convention has 70 parties to it. All right, moving away from the UN Copious treaties, and I'm not talking about the Moon Agreement, even though it's a valid treaty for the 18 states that are party to it, because the US isn't party to it. Neither is Russia, neither is China, so we're going to put the Moon Agreement aside. The Limited or Partial Test Ban Treaty, you'll hear it referred to either way, prohibits any nuclear explosion in outer space. So it's more restrictive when you're talking about use of nuclear explosions or nuclear weapons than the Outer Space Treaty is. That's why I talked about this one when I talked about that example of deflecting an asteroid in the prior part of the lecture, in the prior PowerPoint presentation. Okay, the International Telecommunication Union has a constitution, a convention, and radio regulations that are all considered binding treaty law for the parties. It has universal acceptance. The ITU deals with frequencies and orbital slots as a limited natural resource. So the ITU deals with radio frequency usage not only in outer space, but also in a terrestrial context. Avoiding harmful interference with radio frequencies is important, because if there's harmful interference, then no one is making effective use of those radio frequencies of that natural resource. There are two different methods of assignment that are used by the ITU. Most assignment is done under a first-come, first-served method, which means that a state will register that they're going to start using a particular radio frequency in a particular orbital slot. That'll go on the Master International Frequency Register and be accepted by the ITU and by other states. The other is an a priori method that particularly refers to geostationary orbital slots and frequencies used for those objects in geostationary orbit, so that that particularly limited resource can be managed in an equitable fashion. So it's Article 45 that specifically deals with harmful interference and trying to avoid causing harmful interference with radio services or communications of other member states that are operating in accordance with the provisions of the radio regulations. So in order to be protected from harmful interference, you have to have appropriately registered on the Master International Frequency Register the frequency usage, the object, and the purpose that it's being used for. Those all have to match and be carried out in accordance with the radio regulations in order to be protected from harmful interference by the ITU. Harmful interference is any interference endangering functioning of radio navigation or safety services, on the one hand, or seriously degrading, obstructing, or repeatedly interrupting any other radio service operating in accordance with the radio regulations. So two different standards based on whether or not it's a radio navigation or a safety service or any other kind of service. It requires more significant interference to be considered harmful if it's not a radio navigation or safety service. And then finally, to a military audience, member states retain their entire freedom with regard to military radio installations. That being said, the principle of due regard is built into the ITU regime as well, so that military radio installations should be operated with due regard for other activities carried out in accordance with the radio regulations in order to continue to maintain the efficient, equitable, and rational use of radio frequencies and orbital slots. And so there's our additional language there: must, as far as possible, prevent harmful interference. And that's the end of our discussion of international space law. I know that was really a fire hose and a lot to throw at you. I'm looking forward to what questions and considerations you might come up with for the purposes of our subsequent discussion that we will have as part of the course. Thank you very much.